As we welcome you in for another edition of Chicago's Legal Latte, I'm very pleased to welcome back to our series Brian Warens, who is a shareholder at Lavelle Law. Brian has joined us in podcasts in the past, but it's been a while, and he brings a great deal of information and knowledge regarding estate planning and other aspects of law. Today, we're going to talk about managing taxes with estate planning tools. So, Brian, as I mentioned, it's been a while. Very nice to see you. Thanks for being here today.
Of course, Jim. Good to see you again. Good to talk to you.
Yeah, nice to have this opportunity. We do a lot of podcasts with you and your colleagues about different aspects of estate planning. We look at different aspects, tools. Today we're going to dive into that a little bit. But first of all, let's start at the end. When a person dies, which is what we do planning for at that point, in general, what happens to their assets?
So in general, if a person dies, what happens to their assets depends entirely on how those assets are titled and whether you have any beneficiaries in place. If, something, for example, is just in your name and there are no beneficiaries in place, according to Illinois law, what governs here is the Illinois Probate Act. Your assets go to your heirs as the law defines them. So for some people, it might be children. For others, it might be siblings, nieces, nephews, potentially even further out relations. It just kind of depends on who at that point in time.
Okay, and that's in an undefined state. Tell me how estate planning then helps, clarify that.
I mean, that's a good point. That's undefined. Estate planning is you making the definitions and you defining what happens. It's you saying who gets your assets, it's under what conditions they might get them, and it's kind of taking discretion out of the hands of probate court.
Now, in the news, politically, we hear a lot about estate taxes, death taxes. I think they've been called at various times. That's what we're going to talk about today, how to manage those taxes. But again, let's talk general terms. So when a person dies, the assets they leave behind that go to those heirs, is that considered taxable income in general?
Correct. So anything that you own in your name at your death, it's considered what we call part of your taxable estate, which is subject to estate tax. We always have to think about federal estate tax. Not all states have estate tax. So federally, in 2023, each person has a 12.92, so pretty close to $13 million exemption. So you have to get above that number of assets before you're subject to estate tax at the federal level. And once you exceed that, whatever's over that, subject to a flat rate of about 40%. Now, at the state level, Illinois does have an estate tax. For Illinois, the limit is 4 million per person. So we tend to have to think about estate tax in Illinois because it's not too hard to get to that level. We include things like death benefit on life insurance, potentially ownership interest in the business, homes. It all kind of can add up pretty quickly. And other states don't have an estate tax, like Wisconsin does not. Some states have something known as an inheritance tax, and that's a type of death tax, but it's based more on the relation of the asset or person who you leave assets to, as opposed to an estate tax, which is based on the total value of assets you leave.
So let's talk about estate planning then. When we talk about what you do, I know there's a lot of different tools. There's a lot of different ways that people can set up their estate to have things taken care of. What are some of the key tools that you would use then to help someone manage that potential tax plan?
So trusts, in particular, irrevocable trusts are a key tool in the arsenal. It's functionally a way to get an asset out of your taxable estate. You have a couple ways to do that. I would say the broad name for the strategy is gifting, and one of the places you can gift to is an irrevocable trust. So a gift in general, is say you give $30,000 to a child. That once they have that money, that's considered a completed gift. and that money is out of your taxable estate. Um, Irrevocable trusts are another way to make completed gifts, but without giving an immediate right to the gift. For example, a child too young, so in a irrevocable trust, you put money in there, and then maybe 30 years later is when they can access it, and maybe it grows in the meantime. And in the meantime, that appreciation occurs outside your taxable estate. Another tool we sometimes use are LLCs in conjunction with irrevocable trusts, but that's a little more of an advanced planning technique.
Now, when we talk about trusts, one phrase I have heard is funding a trust. You can establish a trust, but my understanding is you have to fund it. What does that mean?
So funding a trust is, in essence, allowing the trust to do its job. The trust by itself is just a piece of paper. When you fund it, it's, in other words, retitling an asset potentially to reflect the name of the trust, or putting the trust down as a pay on death beneficiary on an account, which, those are two ways to kind of guide assets into a trust so that the terms of the trust will control the ultimate distribution of the asset.
Now, help me understand a little bit. We're talking with Brian Warens today, shareholder at Lavelle Law. And again, these conversations, we only get so far. I always encourage folks to visit lavellelaw.com. You can meet Brian there, read some of his articles, and get a lot of information about topics like the one we're talking about today. So Brian, you talked about different types of trusts, funding that trust. In the estate plan, I assume that you sort of list your assets and say who gets them or who gets what percentage of everything that you own. But you also talked about gifting. So go a little further for me there. Is in my head, when you talk about gifts to someone, it's like I could, throughout the course of my life each year, give X amount to children, cousins, nephews, whatever. Is that different than what you would put in the estate that says this is how things get handled after my death? Where am I confusing the two there?
So those kind of work together. Gifts during life and gifts at death. They're part of that same total exclusion. So
Okay.
You can make at the federal level up, per person up to $12.92 million in gifts during life or gifts at death. It's called the gift and estate tax. It's a unified tax. It's a little bit different at the state level. Illinois, for example, doesn't have a gift tax, so you're not taxed on gifts. So there's sort of an incentive to do more lifetime gifting in Illinois. The way that Illinois treats it is any gifts that you make during your life are added back at death, but they only generate a limited amount of additional estate tax, I'll say. So, for example, let's say you had a $4 million estate, which would be a non-taxable estate in Illinois at your death, but maybe you made $20 million in gifts during your life. So that would result in an Illinois estate tax due of about $250,000-$600,000. So not at all what you would expect it to be, but so there's a lot of advantages to pursuing lifetime gifting.
Now, part of what we want to look at today are again ways of managing this tax impact. What about charitable giving? Certainly those levels, whether they're state or federal, many of us are not going to reach, but there are people who do, and they want to make sure that their money is used in some way. Creating a foundation or setting up a donation. We see many requests from different organizations saying, "Hey, put us in your will, put us in your estate plan, leave money to us." Is that a process that you work with then, and is that a strategy to use?
Yeah, absolutely. So that charitable gifting is another great strategy for clients who wish to make those gifts. The best way to think of it is it's basically an excluded gift, and it reduces the value of your estate. So if you had a say a $20 million estate and you gave away $20 million, there's no estate tax that's ever going to be paid on those gifts or gift tax on those gifts. It's how we incentivize that sort of giving for those people more able to do so. So we speak a lot, I guess in general, there's no limits on gifts, but there's a limit on gifts you can make without being subject to estate and gift tax. For family, generally, you're gonna have to think about limits. For charities, you don't.
Interesting. Now, before I let you go, the other thing you mentioned early on, and I think it's an important thing to look at here. If you're a business owner, if you own a business or a stake in a business, shares in a business, you mentioned that could or is taxable. What can business owners do with what they have built and what they own, so that if they die before they have retired or sold a business, that doesn't become problematic for their families?
Exactly right. There's a lot of issues that can come from not doing proper planning when it comes to a family business. And you see it all the time. There might be multiple family members involved with the business, and something happens to a person. There's a guy in control, and there's a lot of fighting that can happen. So, I mean, part of it is you have to think about planning from the state tax perspective, but when it comes to planning for family businesses, we want to planning that'll family harmony and a business and what the client has worked so hard to build over their lives and protect the employees of that business. So that requires, a fair bit of thought, conversations that solve these issues. So we do have to think about, whether maybe the business gets sold and assets get distributed equally among family members. If, for example, there's no one to take over the business, or, if there are certain children that are more involved in the business than others, maybe they would get ownership interest in the business at the business owner's death, but get less of other assets that are part of the estate, cash assets or securities, for example. But all that has to be deliberately done with an attorney to the right documents.
And let's just wrap up then by sort of indicating how and when. We talked about planning, and you just mentioned working through a qualified attorney. Is any time too soon for someone to start working on an estate plan?
No, I mean, a lot of times, best time is today. You have no idea what's going to happen tomorrow, so plan today.
Get started. All right, Brian, how about people who want to find out more? Where can they reach you? What's the best number to get a hold of you?
Sure. They are more than welcome to call me on my direct number, which is 847-705-9563, or my email address is bwarens@lavellelaw.com. That is BWRENS@LAVELLELAW.com.
Excellent. Thank you, Brian, very much for being here. It's great to talk to you again, and hopefully we'll get to do it again soon.
Sounds great. Have a good one, Jim.
All right. Thanks, Brian.
Bye.